Stevens College of Technology. We're honored to have you here. And at this time, I'll turn the program over to Mr. Ross Etchinger.
Thank you very much. Before I start on this, I just want to thank the Stevens College of Technology very much for hosting this and participating in it. And though sometimes I leave this out, this is probably one of the greatest legacies of Thaddeus Stevens, this school, which provides an education to poor and downtrodden, and to actually provide very necessary occupations in our community. I just wanted to say today sort of had its origins in 2006 when I read an article by none other than Garrett Epps up here, where he was writing for Salon. And let me get my glasses on here. And I think he says, "What's better than a patriotic holiday in July? Pop a brew tonight, then let's celebrate our heritage of democracy and equal rights. We owe these freedoms not so much to the events commemorated every July 4th, but to those of July 21st. On this day in 1868, after a bruising ratification struggle, Congress passed a resolution proclaiming that the 14th Amendment was part of the Constitution. More than the Declaration of Independence, more than the original Constitution, more than the Bill of Rights, it is the 14th Amendment that makes America a democratic country. Or, as I've said, it is the amendment that made America great." It also is an interesting amendment because it has 4 different dates for its ratification. On July 20th, Secretary of State Seward said back on July 9th, they had enough states to approve it. So there you have July 9th and July 20th. Then on July 21st, which is the date that Garrett gave, Congress says, "You're right, it's approved," and certified it. Then, just to make it even more confusing, Seward on July 28th said, "Yeah, it's done, and I certify it again." So that's why we can have this on July 10th. We might as well just have a couple more days, and we are going to be having yet another celebration on July 14th at the cemetery, Thaddeus Stevens Cemetery, to commemorate the 14th Amendment. So in any case, what we are going to be doing today is we're going to be having our panel, which includes Rick Gray, former mayor of Lancaster, Garrett Epps, legal scholar and author of a book about the 14th Amendment, which, by the way, is on sale in the back. We have 4 copies, and for $25, I'm sure Garrett would agree to sign some of those. And we also have Greg Paulson, a civil rights attorney, who will be talking about the day-to-day operation of the 14th Amendment and civil rights. And of course, probably they would like to talk more about their particular occupations and their perspective on the 14th Amendment. After they give a 3 to 5 minute presentation, I will then ask a few questions, prepared questions, and then after that we will open them up to the audience. So without further ado, we'll take one of you, whoever wants to go first. So Derek will go first? Okay. We've chosen you to go first.
So, thank you. It's my understanding that I'm supposed to tell you a little bit about what I do, and then give a few, I'm ready to shout, I can talk right into it. You got it, yours.
It's not working very well?
Apparently not. My name is Garrett Epps. I teach constitutional law at the University of Baltimore, and I am the Supreme Court / constitutional law correspondent for the Atlantic. I am also the author of Democracy Reborn, which is the only narrative history ever written of the framing of the 14th Amendment. And if you think about how many books are written about all the events of Philadelphia 1787, the idea that we have only one account of this truly crucial turning point in American history seems kind of sad. My summary of the 14th Amendment is that you should read the whole thing. My students hate that. That's like 400 words, Professor. Read the whole thing. It all goes together because it was an amendment designed to take a country that had been ruled by something that was called the slave power, and that is the undemocratic dominance of state governments and of the Union by slave states and the slave industry through the Electoral College, the 3/5 Clause, the Fugitive Slave Act, and so forth. And to make that into a democratic country, to what Carl Schurz, one of the key supporters, called a union of truly democratic states, where states would have to observe the Bill of Rights, free speech, free elections, the right to vote, and so forth. And that its overwhelming concern is political. Its overwhelming concern is with democracy. And to the extent that you perceive at any point questions or challenges or problems that are occurring in our national life that threaten democracy at the street level, the 14th Amendment is the place to start. And I know we'll hear from our other speakers some of those street level challenges, and they are constant and they are always new.
I'm going to give a perspective on the 14th Amendment and my career of 50 years. I started out as a VISTA attorney, then a legal service attorney in Pittsburgh in the late 60s and early 70s. Made $42.50 a week and could live on it. Hard to believe. As a legal service attorney, we litigated many class action lawsuits, primarily concerned with welfare rights at the time. Almost everything we litigated was on the due process clause and what the state government could impose on welfare recipients and still comport with due process and equal protection of the law. During that period of time, the only case I ever had that went to the United States Supreme Court, which we lost, was on a question of whether regulation of public utilities is so direct as to cause them to become an arm of the state and make the 14th Amendment apply. I think it was PPL, apply to PPL. In other words, if PPL wanted to cut off your electricity, they would have to give you a due process hearing, was our argument. We ended up having the NAACP Legal Defense Fund actually argue it, and we lost it. Yet on the other hand, this was 72, maybe 73. We were litigating due process issues then for poor people. Then I went into private practice and became a criminal defense attorney. And as a criminal defense attorney, how would the 14th Amendment apply? Well, most of us think that the Bill of Rights, non-lawyers, think the Bill of Rights applied to the states. But if you take the First Amendment, which is probably the best known amendment to the Bill of Rights, it starts off that Congress shall make no law. That would say the states. Freedom of religion, assembly, freedom of speech, Congress shall make no law. So states have the ability to infringe on freedom of speech, freedom of assembly, could have a state religion, could support a state religion, until the 14th Amendment. The 14th Amendment was passed in the 20s, 30s, 40s, 50s, and 60s, I guess, even then. It was incorporation of the Bill of Rights. The Supreme Court said that through the 14th Amendment, various parts of the Bill of Rights became applicable to the states. And I'll give you a couple examples that you're probably familiar with. Escobedo versus Illinois said that, well, even earlier, Gideon versus Wainwright said that you have a right to counsel, and that if you can't afford a counsel, it has to be provided. That was through the 14th Amendment incorporation of the, I guess, 6th Amendment. Would that be right? The 6th Amendment. Escobedo, you could have a lawyer present with you when you were questioned by the police if you requested one. That was incorporation, I think, 2 of the 6th Amendment. Then Miranda versus Arizona, which you've seen TV, you've seen them give the Miranda warnings. That was the incorporation through the 14th Amendment of the 5th Amendment against self-incrimination. So before that, before those cases were decided, a state could question you without an attorney being present. You could be put on trial in a criminal case without a lawyer. If you couldn't afford a lawyer, you could be told, go ahead, defend yourself. If you can't afford a lawyer, you're on your own. Because of the 14th Amendment. And the place I litigated the most probably was Mapp versus Ohio, which was a interpretation of the 14th Amendment that would then include the 4th Amendment, which is the right against unreasonable searches and seizures. Mapp versus Ohio made that applicable to the state and said that if evidence was seized by a state actor in violation of the federal Constitution, prohibition against unreasonable searches and seizures, they could or they must suppress that evidence, and the evidence cannot be used. So those were examples. I was for over 30 years a criminal defense lawyer. So I use those every day in my practice. There's more than that. I think almost all the bill of rights. There might be a few of them that have been incorporated. I don't think you're right to a jury trial in a civil case. Civil jury trial, you don't have a constitutional right to that yet. Excessive fines. There's another one. Then, after seeing the errors of my wife for being a criminal defense attorney for all those years, I made another error and ran for mayor. As mayor, it was interesting, our solicitor used to say to me, once a month, it's nice to have somebody who understands due process as mayor. Because most mayors would say, why the hell do we have to have a hearing for this person? Everybody knows he did it. Why? Well, it's procedural due process, and it affects local government on a regular basis. I see Sam Meekum back there. Sam had a lot of the same experiences and still has some of them in Manheim Township, but also as a criminal defense attorney. As mayor, you couldn't just arbitrarily do things as much as you wanted to. And I used to tell our solicitor, your job seems to be to tell me I can't do the things I want to and tell me I must do the things I don't want to. That's the 14th Amendment.
Hello, my name is Gregory Paulson, known as Greg, and I was asked to tell a little bit about myself and why the 14th Amendment is important to me. I practiced law for going on 45 years now, although I failed retirement 10 years ago. I now work as the Chief of Staff for Representative Mike Sturla, and I also do have a little law practice on the side where I write wills and do some real estate. And most of my work is done in the area of elections and campaign finance law, which is a lot of fun. It doesn't involve the 14th Amendment at all. But I'm honored to be here on the anniversary of the 14th Amendment, and I'm honored to be here on this panel. I should say too that I was on the adjunct faculty of the school here, where the 14th Amendment came up all the time in our classes. Many years ago, I was a defendant in federal court, and it was because of the due process clause that my case was bounced. And while I was going through that process, I was a caseworker for the Camden County Welfare Board in New Jersey. And I got to see a lot of poor people, and I got to see a lot of people of color. And I got to see how people who were not white and were not middle class were treated. And so I went back to law school after my case was done, and I spent some time with the Pennsylvania Civil Rights Division, so the Pennsylvania Attorney General's Office Civil Rights Division, and I was involved with some exclusionary zoning litigation and some discrimination in hiring litigation involving the Philadelphia Police Department. And I actually drafted the memo that the Pennsylvania State Police used in when they could use deadly force. I eventually went on to work at Philadelphia Legal Services, and I was involved, and we had a grant to represent inmates. And we were supposed to represent inmates who had problems with what happens to your child when you're arrested, and what happens to your wages when you're arrested, and what happens to your apartment when you're arrested. And that turned into I spent a lot of time, like 4 days a week, in Grayford Prison, or the House of Correction in Philadelphia, or Grayford Prison, interviewing inmates and getting involved with litigation on behalf of the Black Muslims, on behalf of Black Panthers, and on behalf of the MOVE organization. And each of those pieces of litigation certainly involved due process issues and equal protection issues. During that period of time, I learned something very important. That I learned the difference between the Fifth Amendment and the 14th Amendment. And the Fifth Amendment is one of the original 10 amendments in the Bill of Rights that says that the federal government cannot take away your property or your liberty without the due process of law. And then came the 14th Amendment. And the 14th Amendment actually has 5 sections. And the first section talks about equal protection and due process. And the 5th section says that Congress shall establish by legislation the right for individuals to have their civil rights aggrieved. And out of that one sentence of 15 words, the 42 U.S.C. Volume 42 of the United States Code, Section 1983, and that's the one that gives private citizens the right to sue state governments and anyone acting under under the color of state law because their civil rights have been violated. And so that's where I spent my life as a practicing lawyer in both legal services in Philadelphia and until Rick Gray convinced me to come to Lancaster and work for his organization here in Lancaster. It's the language that authorizes private individuals to sue a government entity or someone acting under the authority of state law to have their rights aggrieved. That can be for damages. And prior to the Civil Rights Act of 1871, when this was passed, the only thing someone can do would be to bring in an injunction action to stop violations in the past, or to stop violations in the future, to make sure everyone followed the law in the future. But under 42 U.S.C. 1983, you can now get civil damages, money damages, if your rights have been violated. Well, I never made a lot of money doing that because most of the time doing that I was working as a legal services attorney. And I can write a book about all of the experiences I had representing inmates, including being shot at and having to go through strip searches in order to get in the courtroom to visit my clients. But that's what I think that the 14th Amendment has done. It's authorized you and me to take on the government to make sure that our rights, if they have been violated, that the government pays for it, that the individual pays for it, and they see that our rights are not violated in the future.
Okay. Well, thank you very much for that. I'd like to start the first question with somewhat
recently, and you correct me if I'm wrong, because I haven't read these cases, the Supreme Court and some of the appellate federal courts are saying that the 14th Amendment means that laws that are passed have to be colorblind, and there's an argument that affirmative action, which advances the interests of African Americans, are in violation of the 14th Amendment. Is that argument's been made and is to varying degrees accepted by some of the courts? Is that?
That's a really excellent question, particularly for this moment. I don't know if all of you, I hope all of you were watching The Bachelorette last night so that you could put away and see the president's announcement. But The Bachelorette didn't give them due process. Like, you're out of here. But sort of like you as mayor, you know, but she doesn't have a solicitor to stop her. You have to go. That argument is made, it has been made every year, that affirmative action, that is programs designed to open up opportunities, open up previously closed institutions for excluded minorities, for women, and so forth, that they are just as unconstitutional as racial segregation. And the Chief Justice Roberts, believes that fervently. He believes that any measure designed to increase the diversity in an educational institution is morally and legally the equivalent of Southern segregation. He is quite irrational on this score. And it was considered really until about 2 years ago, in a case called Fisher versus University of Texas at Austin, the court seemed to be prepared to adopt that rule and say there can be no more affirmative action in college admissions, government hiring, anything else. And then I was in the room, and it was just a stunning moment. When the case was decided, Justice Kennedy had switched a previous vote and wrote an opinion saying we really need affirmative action because unconscious racism permeates our society and so forth. So affirmative action lived at least for another couple of years. Now Justice Kennedy, as we know, is leaving the court, and I do not anticipate that Judge Kavanaugh, the nominee to replace him, is going to be as favorable to affirmative action. So it's entirely possible within the next 3 years we will see the colorblind rule that you mentioned adopted, which I think would be socially unfortunate, but more important to me, constitutionally illiterate. It simply absolutely contradicts what the 14th Amendment was about.
Well, if I could, just to follow up on that last point, and by the way, save one of those books for me back there, because if I'd read it, I wouldn't have to ask this question. But it was my understanding that one of the reasons the 14th Amendment was adopted was to allow the Three-Man's Bureau or whatever to specifically authorize the government to go ahead and provide special programs for people that were formerly enslaved. And now, through this colorblindness, what you're doing basically is reversing the whole purpose, one of the purposes of the 14th Amendment. And being colorblind, really what you're doing is discriminating against the people that this amendment was meant to be passed. Maybe you could tell me if I'm right or wrong.
I think you and I are soulmates on this. I think that the Freedmen's Bureau is an astonishing. There is information about it available in my book, which, by the way, is also on Amazon.com. Bring it right to your house. You know, but is an astonishing historical phenomenon. It is as if it's like something out of time travel. Whoever, Robert Dale Owen and the other people who designed the Freedmen's Bureau, seem to be having a kind of 20th century Marshall Plan mentality about how to deal with the Reconstructed South, including having this organization, the Freedmen's Bureau, that was the first social welfare organization the government ever ran in the United States, that was there to help the freed slaves find jobs, get education, find their spouses who had often been separated as a result of slavery, establish families, own property. and so forth. So yes, the very first program under the 14th Amendment was a very much an outreach program to racial minorities in order to bring them in to the mainstream of society. And as is happening now, late in the 19th century, the Supreme Court and society in general began to say, well, we've really done enough for these people. It's time for them to pick up and do on their own, because really it's all, we need to be colorblind and it's racist to help them. So, the history of the 14th Amendment has a certain melancholy cyclicality, and we seem to be in one of the negative cycles.
Specifically, Professor, was the 14th Amendment was one of the reasons it was passed was to allow or authorize the freedom of the girl. Was that expressed that way, or was that
Well, the Freedmen's Bureau had already been put into place, but then there were people who said, we're going to go to the Supreme Court and get that set aside as unconstitutional. So one of the reasons the 14th Amendment was written and adopted was to make sure that the Civil Rights Act, 1983, which you were talking about, and the Freedmen's Bureau would not be struck down by the Supreme Court. It was that's not the only reason for the 14th Amendment, but it was to anchor those programs beyond question as constitutional.
And now some of the people on the court or in the court would use that very kind of construct and some of the programs.
Yes.
Okay, very interesting. The next question I would like to talk about is due process, and we've been talking a lot about due process here. And I'd like to have you talk about the difference between procedural due process and substantial due process. And Greg seems ready to jump on it.
Well, it was my question, and I should have written down an answer, but I didn't. I think of the differences in terms of the Fifth Amendment and the 14th Amendment. The Fifth Amendment has the exact same language in terms of where your due process rights are. But the Fifth Amendment, as I see it, says that no government entity, the federal government, cannot take or deprive you of your life or liberty without due process, which means there has to be some formal procedure that's been established by a legislative body as to what the rules are before you can be arrested, what the rules are before someone can exercise a search warrant, and what the rules are before someone can be incarcerated or killed in an electric chair or otherwise. So that's what the Fifth Amendment says, but the 14th Amendment says or assumes that there are fundamental rights that people have. And the fundamental rights are not those rights that are, not only those rights that are in the First Amendment and the Second through Eighth Amendments. There are the rights to live the life the way you want them, whether that's the right to have an abortion, or the right to be gay, or lesbian, or transgender, the right to have clean water, the right to have good living conditions, or we can go on and on. And the arbiter of who those rights are become the judges, as opposed to the legislature. And so the substantive rights that people have are decided by the courts, decided by the judicial system. And it takes people like any of you who decides to sue any official because your rights have been violated to say to the world, these are my rights. I have a substantive, and a judge is going to say, you have a substantive right to live the way you want to do. You have the substantive right to be free of harassment. You have the substantive right to live free of fear. And so, on one hand, you've got procedural due process rights are the legislated rules by which government can take property, and you've got the substantive, which are basic fundamental rights that we all have, even in those areas where the government has not yet acted. And the arbiter is the words.
Other members of the panel would like to comment on that?
Well, I'll just say real quickly that it's a confusing thing for people because the term is kind of self-contradictory. It's kind of like saying, somebody said, substantive due process is like pastel green redness. They're contradictory because substantive rights and procedural rights are two different categories, right? So really what happened was shortly after the 14th Amendment was ratified in an extraordinarily clumsy decision called the Slaughterhouse Cases, the Supreme Court, without really meaning to, set forth a rule that said that the privileges or immunities clause of the 14th Amendment had no content at all. Now, most people, from my reading of the record, at the time the amendment was adopted, most people thought the privileges or immunities clause meant the rights in the Bill of Rights and other substantive rights of the kind that you were talking about. And the due process clause had to do with the procedures that had to be used to take someone's property, life, or liberty away. Well, suddenly that clause is gone. The court has completely screwed it up in a way they still have not been able to reverse. And so the judges, as time went on, began saying, this 14th Amendment thing ain't going to work if people don't have any rights, right? In other words, imagine if you don't have substantive rights, you only have procedural rights. You're at home, the doorbell rings, Andy and Barney are standing outside. And they say, I'm awfully sorry, we're going to have to take you down to jail. You're charged with a very serious crime. But don't worry, you're going to have counsel, you're going to have a trial, you're going to have an appeal, you're going to have a jury. Well, what's the crime? He said, well, it's come to our attention you've been eating red wine with fish, and we don't hold it that much around these parts, and so you're going to jail. And he said, well, I have a right to eat Pinot Noir with my fish if I want to. And I said, well, where's that broke down? And that's a substantive right, a right to speak and to think and to live, to raise a family. All of these are substantive rights, and there are some rights that are so important that it doesn't matter what procedures you offer, government can't take them away. And that's what substantive due process means, and it's a kind of confusing term for something that I think we instinctively all understand. My high school civics teacher was, in his way, a genius. He taught the whole lesson. The whole lesson was, he said, due process means fair laws fairly applied. Okay, next. And fair laws, that's the substance. Fairly applied is the procedure, and in our system, the due process clause contains both.
You could take a course in law school. Due process, procedural and substance. And at the end of the course, you probably still would.
I'm going to give you some examples of substantive due process cases that are really good. In one case, I was able to sue 2 volunteer fire companies because they refused to go into a prison to put out a fire. And the substantive issue that was raised was whether or not inmates have the right to live in a facility that is where they're entitled to live without the fear of fire, or without having the walls which are burning and the smoke so dense that they would pass out and people were passing out. I've litigated issues where, as a legal services lawyer, I sued a private water company because the private water company turned off the water in the town of Mount Gretna because they decided that we don't want the water, we don't want the pipes to freeze in the winter. And yet there were people living there, and they had the right to have water. I can see in the future inmates suing private prison companies because the states and some states and some counties have turned over the responsibility of running the prison to a private company. And so the private company's going to say, well, we can do this because we're not going to, we can do whatever we want to do because we don't have the government looking over our shoulder. And my response is BS, because they have taken on government responsibilities. I have litigated the right of an incarcerated mom to have her infant child live with her in prison, because here was a child who was under 6 months old. Mom had just been picked up for stealing formula for her baby, and her mom was out on parole. And so they let her right back in the clink. And yet, a kindly old judge in Philadelphia said, okay, I'm going to let that child go live with her mom, because the mom had, well, there's good reasons for that, as we all know as parents. The mom had a due process right to bring up her child. That's the kind of substantive rights that the 14th Amendment substantive clause, or the substantive reading of the 14th Amendment allows.
You know, as we talk, I think back to some of the early legal service days and litigation of a couple of issues, and I think they were founded on due process, substantive due process. There used to be a man in the house rule for aid for dependent children. In other words, if a woman was destitute and getting welfare, if there was a man in the house, she couldn't get the welfare. Legal service challenged that. That was a substantive due process. Another one, do you have a right to travel? Well, you think, well, where is it? Where is it in the Constitution? You have a right. I'm going to go back to New Jersey tonight. How do I get that right? Some would say that's foolishness, but it's still, a right. There used to be a rule that if you went from Pennsylvania or New York to Pennsylvania, there was a residency requirement before you received public assistance. So if you moved here, I can't even remember how long it was it a year or whatever, the periods of time? The Supreme Court held that infringed on your right to travel. And where was that right found? In the 14th Amendment, substantive due process. Am I right on that? Was that substantive due process? So those are the kind of things that you don't really think. You say, well, of course I have that right. Gail and I were talking about something, my wife and I were talking about something one day. And Gail said, well, that's unconstitutional. And I said, on what basis is it unconstitutional, the artist and the lawyer? She said, I don't know, but if it isn't, it should be. That's substantive due process.
We have a question here.
Very on that, does universal suffrage not count as substantive due process? Is that?
Well, universal suffrage as to women voting?
No, as to I understand there are a few states where if you're a pauper or you're a prison, you may not have the right to vote.
I don't know if that's been litigated or not.
There are two different parts of that. As far as pauperage, that has been litigated, and the court has held that you can't restrict the right to vote to the basis, for example, the poll tax and so forth. A case called Harper versus Virginia Board of Elections. Yes, that was a 14th Amendment case. Unfortunately, by the terms of the 14th and 15th Amendments, felons currently incarcerated or who have been released can be denied the right to vote. And this is a battle that's being fought in a lot of states to restore the right to vote. And some states, like Virginia, which is where I'm from, at one point not too long ago, the governor said, well, he would restore the voting rights of felons as he chose, but each felon had to write him a letter and explain why he was worth allowing to vote, and the reaction to that was pretty bad, and actually the governor himself was later convicted of a felony, so the ironies are rife. in that, but that, yeah.
Did he write himself?
He wrote the Supreme Court a letter, and they said, "Oh, you're a rich guy, you're okay." But he was convicted for a while. But so that's still being fought, the felon status thing. Universal suffrage is not in the Constitution anywhere. We have there is. I always say it's a little bit. The Constitution talks about the right to vote. It's mentioned 5 times. All the rights that we have, the right to vote is mentioned more often in the Constitution than any other. And yet, when the Supreme Court writes about the right to vote, they put it in quotes. And they say the so-called right to vote, because there is no sentence that says, look, dopey, people have a right to vote. What it says is you can't restrict the right to vote by race. You can't restrict it by sex. You can't restrict it by failure to pay a poll tax. You can't restrict it on the basis of not being 21 years old. And so we don't really know the contours of the right to vote. And that is one of the areas of the 14th Amendment that's being fought over constantly. And then finally, of course, after the 14th Amendment was adopted, a number of female suffragists immediately went to court and said this is equal protection. How can you deny adult citizens of the United States the vote just because they're female? And the court, which by bizarre coincidence was made up entirely of men, said, no, we don't like that, next question. And so we needed 75 years to get the 19th Amendment passed.
I'm going to open this up to questions from the audience, but I want to ask one more question, and that's about the current event. How do you see the 14th Amendment playing in the immigrant crisis that we have, particularly with the separation of children from their parents?
It doesn't.
Oh, it doesn't?
It doesn't, and because everything in the immigration crisis is being done by the federal government, and that's the 5th Amendment stuff, as opposed to the 14th Amendment. It is still due process. It's a due process issue, and if we get, if there are people like my cousin's here from Hazelton, she's going to shoot me for this. But if we have people like Lou Barletta, who is running for the U.S. Senate from Pennsylvania, if we had if his proposal that we could discriminate against people of color or because the police didn't think they were citizens, yes, then of course there would be due process issues in the 14th Amendment. But in terms of what's going on now along the borders, with everything being controlled by ICE and the federal government, it's a 5th Amendment issue as opposed to a 14th Amendment issue.
I'll just, you're basically right. I'll amend that in one way that I think people don't focus on, and it's going to be very important over the next 5 to 10 years. And that is, if you go back to the first sentence of the 14th Amendment, which is kind of the big bang of our current democratic system, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. That, unlike the due process clause, is binding on both federal and state governments. It lays out a vision of citizenship, that there is one national paramount citizenship. Now, the idea of citizenship has been contested throughout American history, and we are beginning to see an assault on the idea of equal citizenship of a kind we have not seen for nearly a century, coming from the federal government. It was revealed just last week that the Department of Homeland Security has formed a denaturalization task force that is going to go about and look for citizens, naturalized citizens who have been admitted and taken the oath, but who we now no longer want, and to try to strip them of their citizenship. Just in the year or two after 9/11, we had the Patriot Act, which you recall, that was passed, that made some very extreme changes in civil liberties and procedures and so forth. There was a second act draft called Patriot Act 2 that was floating around finally got leaked to the press and was withdrawn because it produced such a hostile response. But one of the parts of the Patriot Act, too, was to set up an administrative mechanism by which the Attorney General of the United States could designate a citizen as a terrorist and take the citizenship away, naturalized or natural born. And so this idea is out there, and I can smell it coming. I live only 10 blocks from the Capitol. I smell that coming. So it's very important to understand that in that one sense, the 14th Amendment does bind government at every level, and it's very important. If they start moving us back to where we were before with Dred Scott, where there's different kinds of citizens and the government doesn't have to respect their rights, we are in a world of
I'm just going to amend one other thing about the 14th Amendment. If this is litigated, what the important word is going to be nor, N-O-R. Just like in the Clinton administration, the important word was is. If you look at the way the Second Amendment is written and all the litigation over gun rights, there is a one long sentence with a comma in it. But if you look at the 14th Amendment, there are a couple of sentences that are separated by a semicolon and a nor. And what follows nor in one place, where the first section talks about citizens and people born in the United States or United States, but then it goes on, nor shall any state deprive any person of life, liberty, or property without due process, nor shall any state deny any person within its jurisdiction equal protection. So does the nor apply to a citizen or not? And that's going to be litigated.
So, yes, right back there, Don.
Mr. Paulson, I just had a question. Did you win those two cases, the one in the prison and one for the, did you win those cases? The one in the prison fire and the other one got fentanyl water?
Yes. Well, both were settled. We went to the jury on the one in the prison. And that was after we brought in a videotape of the sergeant of the prison staff assaulting the captain to get the keys so he could unlock the guys in the fire situation. Yeah, we won. And in the water case, when they realized that they were actually they had assumed a municipal responsibility, and we had them by the bad parts. They said, okay.
Thank you.
Okay, over here.
Thanks so much. This is a great presentation. At the time of the 14th Amendment being drafted, business was conducted by sole proprietors for the most part, and then we have the rise of the corporations, which still were largely a product of state charters. Well, today you can form a corporation by just filing the right paperwork in Harrisburg or the other 49 states. In the intervening years, the Supreme Court has defined a corporation as a person, and we've gotten extraordinary litigation out of that. I just wonder what your reaction is to that irony.
I'll say something that probably isn't going to be all that popular, which is I don't think the Supreme Court came up with corporate personhood. I think a corporation has always been a legal person, and that the problem is not that our courts recognize corporations as persons with some of the rights under the 14th Amendment. It is that people try to take the position that there's no difference between a natural person and a corporate person, because obviously there are. And we don't want to live in a country in which corporations don't have the right to own their property, which if you are organized as a corporation, the government can just take your property away, or that your government can come along and tell the New York Times Company Incorporated that they can't publish anymore, which I think it would be delighted to do. On the other hand, we don't necessarily have to take, due process is a very flexible concept, so is equal protection. And it means treating similarly situated entities alike. It doesn't mean everyone gets everything, no matter what the circumstances are. And I think the courts have become somewhat inflexible on this. Frankly, because the corporation, the rich and powerful organizations dominate our courts now. They're the ones, that's where the judges come from.
I think that one case I thought about this before, and I thought that if there are a lot of unincorporated associations that could be corporations, for example, the Ku Klux Klan, the American Nazi Party, I mean, if they became incorporated for some reason, then they might fall under the jury. They might have less freedom than they have now. And to some extent, I almost want to be their attorney to incorporate. So I'm shut up.
No, I think if you talk about procedural process, especially corporations, it's a procedural process. It's substantive process. On the other hand, citizens unite to apply the First Amendment corporations, recognize as an individual, really the capacity of the legal, otherwise legal protection beyond the legal, to extend to that point, in my opinion, makes a lot of what the laws have to do. Would you agree with that?
I would. I think that the problem with Citizens United is not limited to the fact that it recognizes this right of corporations. It's the main beneficiaries of Citizens United have been rich individuals, right, like the Koch brothers or Sheldon Adelson. Because Citizens United explicitly says the following: it is not permitted under the First Amendment to consider whether our electoral system is fair or whether it is dominated by concentrated wealth that drowns out every other voice. The court says the First Amendment doesn't allow government to consider it. That, frankly, is ridiculous. It doesn't pass the smell test. Of course you can. And I always tell people about that. If you imagine going to your town council, imagine when you were mayor, and you would have a city council meeting and there'd be open for comment, right? And somebody would finish, you have 5 minutes to talk about this proposal. The person would start talking. And then after 5 minutes, it said, well, your 5 minutes is up. No, you can't do that. That violates the First Amendment. I get to talk all I want, even if I drown out everybody else. Well, no one would believe that. But that's in essence what Citizens United says. And it's completely, it is a terrible decision.
Yes.
By the way, the screener. This went over will be used one of your buzzer.
I'd like to go back to your opening discussion about the original intent behind the 14th Amendment and put it in perspective of the discussion or the debate for folks that follow